So we had a conference where, going through the process of the pretrial portion of the case. We've provided a reply to the defendant's motion to, we provide an opposition to the defendant's motion to sever the counts of the indictment. He's asking for time to reply. I think that's March 12th. And then there's this issue with regard to discoverable materials. Defense is claiming that they need more materials. So rather than argue the point of whether or not they're entitled to these materials, even under our ridiculously broad New York state discovery statutes, we just said you can have them. But it takes a while to download it, so we're waiting for that. So that should be done by March 12th, and at which time we are going to set a date for hearing. We certainly are eager to start that hearing, and we have a number of witnesses, so we would like to at least start at least one of our expert witnesses to begin the Frye hearing. So that's about it. Does anybody have any questions?
Mr. Tierney, can you talk about the soundness of this new science that the defense calls magic?
Okay. So first off, newness of science. You as a adult person has gone to the doctor and has had relatives, unfortunately, who have gone to the doctor, and you have relied upon this science, and your loved ones have relied upon this very science to receive the sound medical treatment that you've all gotten. It's prevented people from dying from disease, it's detected diseases, it's used in amniocentesis, it's identified war dead, it's identified remains of 9/11 people, 9/11 remains. We've been able to reunite those remains with their family members, even though there's a minuscule amount of DNA present. Anthropologists have used it to identify Neanderthal bones, to establish relationships between prehistoric remains. So this science has been around for many years, and if the defense wants to call it magic, that's fine. The defense can call it whatever it likes, but we will determine that at the hearing. We look forward to that hearing, and I can tell you, this is sound science. It is the future of DNA analysis, both in New York State and in this country.
He keeps also bringing up the point that he keeps saying Austria, hopefully pronouncing that correctly, is not accredited in New York State. Your response to that?
Okay, so this is so the accreditation has to do with forensic laboratories. It has to do with criminal forensic sciences. Anytime you have something new, right, there always has to be the first of something. So this is the first time we're taking this sound science and we're applying it to the criminal forensic area. So accreditation, all that means is all of the labs that do this, they follow a particular procedure and a particular set of rules and guidance that has been set up by the applicable community. In this case, labs that do whole genome sequencing, WGS. Well, what if you're the first lab who ever does that? How do you get accredited? You can't get accredited because there's not a community in which to do it. So this is a new science. It is an emerging science. And so the accreditation process is happening as we speak. But back in 2020, when Austria first started working on this case, that accreditation was non-existent. So, when the applicable DNA technology that is used now is STR, short tandem repeats. In 1996, I believe I did the first case in Suffolk County. I believe it was the first case in New York State. Back then, they didn't have accreditation in New York State for STR. We went to a North Carolina lab. Then it got brought into the forensic realm, and then it became generally accepted. Prior to that, we had PCR. Same thing with PCR. Prior to that, it was RFLP. Same thing. This is all just a process, and whether or not a a scientifically recognized modality is accredited or not when it's brand new in a particular area of forensics. That's not the standard. The standard is the Frye standard. So we'll answer the Frye standard. All the rest is noise. All the rest is just people trying to deflect from the Frye standard. Let's talk about the Frye standard. We are required to follow the Frye standard. That's the standard we'll follow because that's the standard that we're legally required to follow. And you could talk about what the standard is for blood banks, and if I ran a blood bank, I'd be very nervous. Fortunately, I don't run a blood bank. I'm a prosecutor, and I'm dealing with forensic scientists who are dealing with forensic cases. And we'll follow the law, not for blood banks, as is in the public health law, but we'll follow the law for forensic science and criminal cases.
Sir, the 5% that he's still waiting to get, what is that 5%? What encompasses that?
So, and look, this is a very, the amount of data that is generated, you have, with regard to whole genome sequencing, you have about 3.3 billion base pairs in your DNA. Over 3 billion, certainly. And all of that data has to be analyzed for one hair. We have numerous hairs in this case. So my point is, we're talking about a tremendous amount of data. As we were preparing the discovery in this case, we were giving the defense the discovery on a rolling basis. In the end of January, I believe it was January 28th, we get this 14-point letter where there's a claim by the defense that they don't have all this material, or at least they can't find it, which, I understand. So what we've done is, even though there was a lot of material that we've already provided, the vast majority in the 14-point letter that we already provided, what we were going to do is, so there was no confusion, we were going to go point by point and say, you're asking for item 1. I'm doing this by way of example. We've already given you number 1. But regardless, here it is, so you can find it, rather than have to hunt for it. Same thing with number 2, and we went all the way down through number 14. So it's a tremendous amount of stuff. So it takes us a long time to download it. We've been doing it for 8 days. We're going to continue to do it. The point being, the defense has already got it, and I would say a lot of the stuff would be outside our already overbroad discovery statute. So we're giving them, I would submit, we're giving them more than we're required to do under law, but we're just doing it because we feel it's the most expedient thing to do rather than fight, rather than object to it and fight. It would be like if someone was to create a map, right? What's the discovery on the map? Well, did you use your computer? What is the software? All the software in that computer, we want copies of all the software in that computer. We want all of the software that the software used to create the map that you made. So listen, the defense is being very diligent in asking for this stuff. We think they're being overbroad. It's not for us to say. It doesn't really matter. The only problem with it is it takes a long time to acquire the materials. If they want it, whatever, they could have it, but when you're asking for that volume of stuff and on such a granular level, it takes a long time to download. So,
and that's all like DNA stuff. It's not like phone records or
well,
anything like that.
it's DNA stuff, but it's you're asking about the electronic, and the software, the electronics and the software that's used to examine your DNA data, which is all of these software things and all of these software programs, and they're asking for the software programs. And they're asking for the programs they're asking for the programs that run the software. They're asking for the software that runs the data analysis as well as the software that runs the software. So, at what point is enough enough?
And all of that is included in the 14 items.
All of that is included in the 14.
District Attorney,
Many felt today a date would be set for the Frye hearing, and even the judge himself seems to be getting frustrated with how long this is taking. I mean, what is the holdup? What is the delay that it seems every time we come back to court, there's additional things being asked for, new things being asked for? What is the holdup that we're not able to set the, or the dates
I
are?
thought I just explained that.
Well, is it frustrating for you and
Look,
your
this
office?
is the process. This is the process. The defense has a job to do, and they're doing it, and they're doing it in a diligent way. You know, we have a certain position with regard to the relevance of this and whether or not it's discoverable under our discovery statute, but we're going to provide it nonetheless. That's the easy part. The hard part is you say we want everything. The defense says we want everything. We say we'll give you everything. Now, how do we, when we're talking about complex scientific processes that billions of calculations, electronic calculations, computer calculations, how do you get that? Well, it takes a long time to download. So that's what the situation is. I would submit that we have witnesses. We have witnesses as to the general science, and perhaps we could start those witnesses. So we'll see. We'll see what the judge says. Again, you as the media and members of the public are kind of seeing this. Like, this is typical of our cases. This is why it is difficult to prosecute cases and comply with our laws. It's a process, and we're going through it. But to say it's frustrating is, that's just the process.
Can you explain your opposition to separating the charges? Severing
Sure.
the charges?
The theory of our case is this defendant is a serial killer who meticulously and methodically hunted down and murdered 7 women. That is our case, and he did use the same methodology. Our allegation is he utilized a planning document in which he laid bare his intention to do this, and so as such, under the law, a lot of the evidence of one charge would be admissible in court as evidence of the separate charge. Specifically, the DNA evidence, the phone evidence, some of the financial evidence, the searches he made, the mementos he alleged he had kept. All of these pertain not to one witness, but all multiple witnesses, if not all 7 witnesses. So if you take all of that evidence and you say that all of the evidence pertains to allegations of guilt, allegations as to all 7 victims, under the law, we're entitled to try that case. It's properly joined. So and for that and judicial economy, and for sparing our witnesses, having to do something 7 times as opposed to doing it once, for all those reasons, we're opposing.
You were being very collegiate or very professional, calling the defense's dragging this out, being diligent. We didn't get to hear the conversation in the judge's chambers. You did. When you came out, first of all, the defense came out like 2 or 3 times, beat red, looking for papers, running back in. It looked like he was going in and out of a fight. Was there any kind of discourse in the back there that led you to believe that this is the last time the judge is going to allow another one of these briefs to be filed and another delay? No, listen, we there is motion practice, and that's the thing, that, if the defense has grounds for a motion and they could articulate those grounds, they could file the motion anytime they want. So that, again, that's part of the process. I think that when we initially went back, again, the tenor of the conversation in the back was no different than the tenor of the conversation on the record, and the subject matter was encapsulated in the public portion of the conference. What the defense attorney was doing is we had severance motion, we had hearing date, we had discovery, we had Frye motion, so we had a lot of issues, and I think initially we went back thinking we were going to talk about one issue where we ended up talking about all the issues.
So, not to speak for defense counsel, but I think he was just going out back and getting some papers pertaining to issues that initially were not believed were gonna be covered with the judge.
Is it your hope that by the next court date in March, all the evidence will be handed over to the defense?
All the evidence in the, with regard to the Frye, our position is all the evidence has necessary to conduct the Frye hearing has already been handed over. But what we're doing is, we're responding to this 14-point letter, which was provided to us on January 28th, again, consisting of a lot of stuff that we already gave over, but we're putting it all in one or all in one response, so there's no confusion. So when the experts or the investigators that the defense is working with, they could go to item 1 and get all of the information on item 1 instead of having to go through the trove of stuff we've already given them. We're doing that because we think that in the end it will make things go faster.
I feel like we asked
Do
this.
you expect the judge to decide on the severance issue when the defense responds to your letter, or is that something that could take longer?
I mean, it would, I mean, you really have to see what the, so we've got an opposition, they have a reply. We could ask for a reply. We probably would only do that if the defense raised something that hasn't already been raised and we can get a chance to answer to. So it's really up to the judge. Obviously, the judge is gonna wait until he fully receives the papers in the case.
I feel like we ask this every time, but after the Frye hearing, do you feel like you're any closer to a trial date
Of course,
actually being set?
of course, but then, you've got severance, you've got a lot of other issues, and again, I'm not gonna, the defense doesn't need any help from me as to how to do their job, but I anticipate, certainly other motions will be contemplated, whether or not those motions are filed, that's for the defense.
Thank you.
Thank you.
Okay, thank you.